This meeting of the Escambia County Board of Adjustments, December 21, 2022, is hereby called to order. With 5 members present, we have a quorum. Will the clerk please swear in members of staff?
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Horace?
Yes.
Thank you.
Members of the board, copies of staff's resume have previously been provided and remain on file for reference. The board has previously recognized staff as expert witnesses. Do we have any questions regarding the qualifications of the staff? Seeing none, would we like to swear in at this time the new member?
Yes, please. Ross, will you raise your right hand? Ross Patton, do you solemnly swear or affirm that you will support, protect, and defend the Constitution and the government of the United States and of the state of Florida, and that you are duly qualified to hold office under the Constitution of the state, and that you will faithfully perform the duties as an Escambia County Board of Adjustment member, so help you God?
I do.
Thank you.
The board meeting package for December 21, 2022 with the Development Services findings of fact has been previously presented to the board members. The chair will now entertain a motion to accept the BOA meeting package into evidence. Do we have a motion?
So moved.
Do we have a second?
I'll second it, Mr. Chairman.
All those in favor raise your right hand. Passes unanimously. Do we have proof of publication?
Yes, sir.
Did the publication meet all legal requirements?
Yes, sir.
Chair will now entertain a motion to not require the reading of the previous minutes. Do we have a motion?
So moved.
We have a motion. We have a second.
Second.
Those in favor signify by raising your right hand. Passes unanimously. Members of the board, have you reviewed the resume and the transcription of the Board of Adjustment meeting held on November 16, 2022? Upon your review of the resume and the transcript, are there any additions, deletions, or corrections? Seeing none, the chair will entertain a motion to resume that board adjustment meeting on November 16. Do we have a motion?
So moved.
Do we have a second?
I'll second it, Mr. Chairman.
All in favor, raise your right hand. Vice Chair, would you please read the purpose of the Board of Adjustment?
Excuse me. The Board of Adjustment hears administrative appeals, variances, and conditional use requests. These hearings are quasi-judicial in nature. Quasi-judicial hearings are like evidentiary hearings in a court of law, however, less formal. All public testimony will be taken under oath, and anyone testifying before the BOA may be subject to cross-examination. All documents and exhibits that the BOA considers are entered into evidence and made part of the record. The giving of opinion testimony will be limited to experts, and closing arguments will be limited to the evidence in the record. After hearing the testimony and arguments for and against the proposed action, and before making its decision, the BOA will consider the relevant testimony the exhibits entered into evidence, and the applicable law. Because the decisions of the BOA relating to variances, conditional uses, and extensions of development orders for site plan approval are final unless overturned by a court of competent jurisdiction, the county may issue development orders and permits for properties in accordance with the decisions of the BOA. However, if an applicant requests the issuance of such an order or permit, and such an order or permit is issued, the applicant and not the county shall bear any risk that such decision may be set aside, the development order or permit may be revoked, or the development may be otherwise enjoined by the reviewing court. An applicant for relief from a decision of the BOA from said actions or any agreed party as defined by state law may seek review of such decision by filing an appropriate pleading in a court of competent jurisdiction within 30 days of the BOA decision. The date of the BOA decision shall be the date the BOA voted at the conclusion of the hearing. Whenever the BOA denies an application, no new application for an identical action on the same parcel shall be accepted for consideration within a period of 180 days of the BOA decision. Any person aggrieved by a decision of the BOA relating to an appeal of an administrative decision may, within 15 days thereafter, apply to the circuit court for review. Each individual who wishes to address the board regarding a particular issue must complete the blue request to speak form and submit it to the clerk of the board. These forms are located on the table at the back of the commission chambers. You will not be allowed to speak until we receive one of these completed requests to speak forms. We must have these completed forms for the public record.
All written or oral communications outside of this hearing with members of the BOA regarding matters under review today are considered ex parte communications. Ex parte communications are presumed prejudicial under the law and must be disclosed as provided in Board of County Commission Resolution 96-13 before a decision by the board on an administrative appeal, a variance, or conditional use request. The chair will ask, as each case is heard, that any board member who has been involved in any ex parte communication regarding the respective issue to please identify themselves and describe the communication. The first case is case conditional use 2022-17. Board members, has there been any ex parte communications regarding this case? Seeing none. Does anyone have knowledge or information obtained from a site visit or other sources? Seeing none. Does any board member intend to refrain from voting due to a voting conflict of interest? Seeing none. Would the individuals who are party to this item please come to the podium and identify yourself and state your address and be sworn in? Mr. Colby.
Roger Kobe, 14595 Innerarity Point Road, Pensacola.
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
And you have seen the staff's findings, and are you in agreement with staff's findings?
I am in agreement with the staff findings, yes, sir.
Okay. With your permission, we'll go ahead and let the staff make a brief presentation, and you'll have a chance to rebut if there's any such thing needed. But if you'll just have a seat, we'll get that and then call you back.
All right, thank you.
Good morning, Board. Kayla McCurdy, AICP, Senior Planner, Escambia County. This is a conditional use to allow an accessory structure in the front yard of a waterfront lot. Here we have our location map shown along Innerarity Point Road. This is our 500-foot radius zoning map showing the zoning of medium-density residential. And our future land use map of mixed-use suburban. There is some flood zone on the property, a flood zone AE. And this is an aerial map showing the lot. This is our public hearing sign that was posted on the property. This is looking east towards the site from Capino Lane. This is looking south towards the site from Innerarity Point Road. There's two entrances to the property. This is looking south from the site towards the waterway. There currently is a house that is under construction back in that area, as you see. And then this is looking towards the general location of the proposed building, if approved. This is in reference to an oak tree and the findings that was stated by the applicant, the avoidance of that said tree, so we wanted to make documentation of that. And finally, this is looking east along Innerarity Point Road, looking west along Innerarity Point Road, and looking north across Innerarity Point Road. That concludes our maps and photography for this conditional use case. In general, our findings show that the applicant did address all the conditional use criteria that would allow for an accessory structure to be located in the front yard, and has met the LDC requirements for that. Staff does recommend approval for this case. If the conditional use is approved, the applicant still must obtain all necessary permits prior to construction. Additionally, the standards of construction for it to be located in a FEMA's flood zone would need to be met with the Land Development Code and the Florida Building Code. But we do recommend approval on this.
Thank you very much. Board members, any questions of the staff?
Go ahead. I had one question, and I can't find where it was, and I read it, but there was something about the side setback being on the north side or something. Do you have the drawing of the setbacks?
The site plan drawing. Yeah, that was taken into consideration, and it's an odd-shaped lot,
Right,
and with the consultation with staff, we would consider that not a front lot line, but it's functioning as a side lot, and we were in agreement with that. And
okay, so there's this is just a conditional use, no variance
no,
on,
for accessory
a setback.
structures, since we're considering that a side, and in functioning as a side, accessory structures just need to maintain 5 feet from side and rear property line, so.
okay.
Mhm.
Thanks.
If I remember reading this file last night, this proposed structure will be something like 2,700 square feet, which is fairly
Sure,
large.
Sure.
Isn't there a ratio about accessory structures to the size of the home itself?
Yes, sir, that was taken in consideration with staff and in conversation with the applicant. The home that's been approved on the property is about 6,500 square feet, so it's a fairly big house that's being built on the property. That's what the approved plans were submitted for. So we take lots less than 2 acres are allowed up to 50% of the gross floor area of the primary structure. So technically, he would be allowed to go up to 50% of that 6,500 square feet of that principal structure, and the applicant is proposing at 2,500 or so that would meet that requirement. So it's 50% is the ratio.
Okay. And is the purpose or the reason, the underlying reason for this application essentially for the request to have the placement where it is in the front is because of the tree in the backyard?
It was stated by the applicant that there is a oak tree that is on the property, and he's seeking to keep the tree. In addition, I would say that the primary access, and the applicant may be able to speak to this himself, but the primary access probably to get to that accessory structure and the large house is off a side street. There's some type of a driveway, as you can see from the drawing, that's utilized to get to the actual property. If it was moved any further, and we kind of looked at this in conversation, it may potentially impede the access that's already there. So I would say it's more than likely the oak tree and the access that's used was taken in consideration with the proposed location.
We have one speaker in favor. Randy Croft, did you want to make any comments?
Oh,
She's the applicant for the next case.
Oh, okay, sorry. Board, any questions of the applicant? Applicant, any comments you would like to make?
Just one last question. Could this structure be built traditionally where, in the back of the property?
it potentially could, but staff would highly caution that due to, A, flood zone requirements and the placement of the current house and under construction. And then you're going to run into some kooky stuff with our marine, estuarine, riverine setbacks. Certain structures, if they're not water dependent, such as docks and gazebos, they have to maintain at least a 15-foot, sometimes more, from marine estuarine bodies. So that may get a little bit more complicated, a little bit more tricky if it was placed back there. And I think the intent with some waterfront lot stuff is people like to maintain the aesthetics of that waterfront. It could go back there if the applicant so would wish, and it wouldn't require this process. But there would be some unique things maybe. You get into more, probably higher flood zone standards. Obviously, it's not a accessory dwelling unit or something like that. And on that note, we did discuss with the applicant, if this is not for an accessory dwelling unit, this is for a primary accessory structure in the front yard. But staff would be more general in going through this process for an accessory structure, because then you get into more environmental concerns, possibly getting it closer to that water body, in our opinion. But it could be done.
Board members, any other questions? The chair will now entertain a motion regarding this item. In your motion, please state where you or the staff's findings of fact. If for any reason you did not agree with the staff's findings of fact, address each one. Chair is open for a motion.
I'll make a motion to approve staff's findings of fact.
We have a motion by Jennifer. Do we have a second? We have a second by Ross. Are there any questions? If not, those in favor of the motion signify by raising your right hand. Passes unanimously. Thank you all. The next case is conditional use 2022-18, 1000 Block N, Blue Angel Highway. Board members, has there been any ex parte communication regarding this case? Seeing none. Does anyone have knowledge or information obtained from a site visit or other sources? Seeing none. Does any board member intend to refrain from voting due to a voting conflict of interest? Seeing none. Would the individuals who are party to this please come to the podium, identify yourself, state your name and address for the record, and be sworn in by the clerk.
My name is Brandy Crops. My address is 10663 Heatherwood Drive, Pensacola, Florida 32506.
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you.
And were you provided with a copy of staff's findings of fact?
Yes.
And I'm assuming you agree with the staff's findings since they were in your favor. So if, with your permission, we'll go ahead and have staff make a presentation, then you can make any comments necessary.
Thank you.
For this case, the applicant is seeking conditional use approval to allow a place of worship within the MDR zoning district. This site is along Blue Angel Parkway, and this is our location map. This is our 500-foot radius zoning map showing the zoning of medium-density residential. And this is our future land use designation map of land uses. The future land use is mixed-use suburban. There are some flood zone issues on the property that would need to be resolved at the time through the development review process that the applicant is aware of. And there are also some environmental wetlands that are located on the rear of the property. There is a site-specific wetland delineation that's been provided, and that will need to be adhered to, and those requirements at the DRC process as well. This is the aerial of the property. This is our public hearing sign that was posted on the property. This is looking across Blue Angel from this property. There is a church across the way there. This is looking northeasterly along Blue Angel as it runs. And the site is currently wooded, and this is looking south towards the site. This is looking southwesterly along Blue Angel. And that completes our maps and photography for this case. I would let the board know that the applicant has currently submitted for preliminary review with our development review process and has begun that. And obviously, they would need to get approval from the board to essentially continue for this proposed use on this piece of property. Staff did find that they can address all the conditional use criteria that would allow for a place of worship in this MDR zoning district, and we do recommend approval pending completion and adherence to all the requirements of the site plan review process.
Board members, any questions of staff?
Do you know about how large the structure is, the building itself
The site plan.
is gonna
Yeah,
be?
we can pull up the site plan. I don't think it was documented in the application itself, but I believe, if I recall correctly, in the development review process, it may be, what is that, a 60 by 100? 6,000 square foot. I guess that's more than typical for a place of worship. I would note that in this general area along Blue Angel, it's fairly vacant. But really, the only things that are there, we didn't find any residential uses in the area, but there are some other churches that are kind of scattered. If you look at an aerial, we did note that in our findings. There was a adjacent church, a few parcels to the north along Blue Angel, that we found in 2006. They went through this similar process to allow for a place of worship. So there's kind of a little pocket of churches here, we found, so. But it looks like it's 6,000 square foot for the building footprint.
And do you have some type of map that can show me like the nearest intersection? I'm not terribly familiar with the Blue Angel,
Yeah, maybe the location map might be able to do it too.
exactly where this is along Blue Angel.
We'll see if we can pull it up here. It's more on the northern side of Blue Angel Parkway. Should head up 1,000 block Blue Angel. Yeah, that's fine. Oh, there we go.
If I recall correctly, there is an Episcopal church in quite near this area.
Yes, sir.
Is it on the same side of the road as this applicant's?
Yeah, I believe it is. So there's two churches. We'll pull up the aerial in a moment and we can point those out. They're somewhat separated by two vacant parcels. So there's kind of a church, a vacant piece, this proposed church, a vacant piece, and then another church. I don't think they're affiliated with each other in any way that I could find. They're different denominations, it appears. And in addition to that, there appears to be some type of other church across the way that you saw in the photos.
Hey.
But yes, there's an Episcopal church right down the road that I believe may have some type of childcare and those
It
type of.
may be just photograph, but the photograph you showed us of the church that's across the road, it appeared to be on the higher ground.
It may be. It very well may be with the flood zone and those type of things. Again, it might be a little deceiving due to the fact that it's more of a cleared type of lot. But again, all that would need to be vetted at the time site plan review is conducted. The applicant's aware of our process. Again, they have gone through the preliminary review stage, and at this point, if they would attain approval, they're preparing to submit engineered drawings and things to county for meeting those requirements and everything that's needed. If you can zoom in a little bit, Rachel, yeah, to the parcel. So the Episcopal Church is right there to the southwesterly. And then you have somewhat like two vacant pieces of property between it, our long skinny piece of the subject property. Another vacant type of piece, I believe that might be owned by the next church up the road. And I can't remember what its denomination is again. And then there's some type of junk storage facility right there further north. But yes, there's kind of like a little group of churches. I believe the one that you see kind of to the north on the same side of the street did come through this process for some type of expansion we found to build a little bit larger building about 15 years ago.
If I remember reading the report or the file, there was a comment in it, and I don't really recall where, but describing the land itself as being in a, quote, severe flood zone.
Yes, it's located in flood zone AE, and all that would need to be taken into consideration. Again, I'm not a floodplain manager, but yes, the applicant is aware of that. They realize there's going to be engineering that's needed, and there's going to be FEMA requirements that would need to be achieved for this building. apparently both of the other churches are there, and they realized that they need to do that. Mr. Jones?
Yeah, Caleb is absolutely correct. I mean, that's something, that's a FEMA requirement. Whatever FEMA says, whatever the county code says, whatever our building inspection department says, that's something that they're gonna have to comply with. They can, whether any structure is within those floodplain requirements, they have to comply. And I know that they've already did their due diligence, they are aware of all of that. Being in a flood zone does not prohibit development unless in a floodway.
Right.
It's a very, very distinct difference. Being in the floodway, and I'm not a certified floodplain expert. Those are the things that come a little different. But you can definitely build in a flood zone as long as you meet all of the FEMA and the county's requirements. It happens all of the time, especially while this not really being surrounded by residential or commercial use except churches. That's why staff can say, yes, we recommend approval on this, regardless of all the environmental constraints, which they got to abide by. The property's wetlands.
Sure.
They can't work around those. Those are DEP, Army Corps. So all those things will definitely be looked at and reviewed very thoroughly and sufficiently during our site plan review process, like any other project.
And just to piggyback on Mr. Jones, the applicant has provided the county with a wetland survey provided by Wetland Sciences. We have reviewed it. They are aware of our buffering requirements. You know, they essentially can't do anything with those areas. If they do, they would have to go through state permitting and that whole rigmarole. But it appears, based on their preliminary design with their parking lot and building, they don't anticipate any impact to the wetland areas with their development. So may not be much of an issue. The FEMA requirements for the flood zone is going to be something that would have to be achieved by the applicant. So.
I have a question for the applicant, if that's acceptable at this time.
Sure.
Can you come up to the podium? This facility is going to be a place of worship. Is it going to be also any type of daycare or educational facility as well, or is it strictly a place of worship?
At the moment, it is only a place of worship.
Okay.
I have a question too. What do you estimate the number of parishioners, vehicles that you're going to have to accommodate?
I don't think I can answer that. I'm not sure. At the moment, there is one parishioner here in Pensacola. I'm sure there will be more that will grow, but at the moment, they have one.
Just one person is in this particular church, right?
Right.
Okay. What does their site plan show for parking?
Pull up the ratio of the parking. Again, this was just a preliminary, it's been done. So,
And the parking is based upon the size of the structure, not the, and as a matter of fact, we can't. Other laws that supersedes us, we really can't federal laws, we really can't get into those type of issues. That's why our parking is based upon the structure of the building, not the amount of parishioners.
so our parking
Yeah.
ratios and the ITT data, it recommends 1 per 35 square feet in principal assembly area. That's kind of getting into some DRC stuff. And once that's proposed, again, this was a preliminary site plan, so this is probably going to change. Environmental impacts or anything probably couldn't. We did recommend places of worship do have some exemptions concerning on-site parking, possibly not having as much concrete or something like that. Those are things that are being looked at with the applicant right now.
And remind me, if you know, you may not know, Blue Angel, is it at capacity now?
I'm not, yeah, that's a state road. I'm uncertain. I'm
Okay.
uncertain.
Being that that is in a arterial road regulated by the state. And they're gonna have to get in contact with FDOT, and their standards will apply as far as capacity levels and driveways and all those type of stuff. That's truly regulated by the state.
I see have no speakers signed up. Would the applicant like to make a closing statement or make any comments? Not necessary.
Mr. Chairman, I have one more question
Sure.
for staff. Is this city water and sewer?
I believe ECU Way, I'm uncertain of the sewer availability. Obviously, if it's septic tank, it would need to go to the Florida Department of Health. I would need to pull up those DRC comments to see exactly how they commented on that, but I would assume that the water is going to be provided by either ECUA or Peoples, someone out there. But I'm uncertain. The applicant did state that all those things will be met, and I would find in my findings here, the applicant states that all the required services are available and are adequate for the proposed use. So.
If I understand your testimony and the file, this parcel is located in a flood zone that has wetlands. A good part are in wetlands. Is that right? Am I?
Yes, sir. This is in a FEMA flood zone, the majority of the property, and the applicant did provide a wetland survey, if you can pull that up. We'll get it pulled up for you. Again, there's the wetland report. Essentially, from a staff perspective, we don't want any of that to be touched. The applicant's not proposing to touch any of that. Those things may kind of get into the more DRC stuff, but that may be beneficial when it comes to stormwater things and discharge and attenuations. But the applicant's not proposing to impact those with their preliminary site plan. But yes, it's in a FEMA flood zone, and there are wetlands located on the property to the rear.
Board members, any further questions of staff or applicant? Seeing none, the chair will now entertain a motion regarding this item. In your motion, please state whether or not you adopt staff's findings of fact. If for any reason you do not accept staff's findings of fact, please go through all the motions, all the criteria, and address each one specifically as to why you do not concur. Do we have a motion?
I'll make a motion to accept staff's findings of fact. I understand that they're going to have to go through probably an extensive site review process as well as the wetlands with DEP as well as the county. I would suspect that due to that, the site plan that we've been shown will probably change, maybe even decrease in nature, depending on the stormwater and the sewer issue. But I think the staff will, during the DRC process, will handle those comments.
We have a motion by Jennifer for approval of the case. Do we have a second?
Second.
We have a second by Marty. Any discussion? Those in favor signify by raising your right hand. Passes unanimously. That concludes our cases. Do you have any words of Scheduling,
So, just as we discussed before, we are going to have a meeting Thursday, January 12th at 8:30 a.m. for only an appeals case, which I do have a quorum for. And then the following week on your normal scheduled Wednesday at 8:30, we will have a normal Board of Adjustment meeting that I have 2 conditional use cases for.
That appeals case, does that mean that we're gonna have like attorneys involved,
Yes.
or? Yes,
Uh,
okay.
The applicant could have an attorney, or he could represent himself, but
We have our,
will be represented.
Sure, okay.
we don't have Christian or attorneys at BOA at so.
And I'll have a court reporter here, and
and what was that date again?
Thursday, January 12th,
And then followed by,
Wednesday, January 18th. And then you don't have to come back till February.
does staff have anything else that we need to know about?
Well, we appreciate you letting us present for you. I know Mr. Homer is normally your guy at these things, so we tried not to break it for him, but he's out with some family doing some vacation stuff, so he'll be back soon, and he'll be back for the upcoming meetings. But Merry Christmas to the board, and have a Happy New Year as well.
Thank you.
And I do wanna say this, one thing y'all may not know about Caleb, he's a very, very modest person. Caleb is a certified planner, AICP certified. So therefore what he says sometimes have a little bit more if they go to court. Being that he's certified, that's favorable for the county.
Thank you, Mr. Jones.
Thank you very much. Counselor, do you have anything you need to tell us? I do not. Okay, thank you. Merry Christmas to all of you.
Yeah, and we appreciate the work of the board and Mr. Jones, and we look forward to a whole new show in 2023.
It is gonna be that. Thank y'all.
Thank you. Thank you, sir. Without objection, the meeting is adjourned.